Thank you. We will now move to hearing testimony from our first panel. Our first panel will address the Federal Bureau of Investigation's Carnivore program and its role in federal law enforcement in the digital age. On this panel, first, we would like to welcome Dr. Donald Kerr. Dr. Kerr is an assistant director of the Federal Bureau of Investigation and director of the FBI's Lab Division, which develops surveillance and tactical communications technologies. Next, we will hear from Larry Parkinson, the General Counsel for the FBI. Following Mr. Parkinson will be Kevin V. DeGregory. Mr. DeGregory is Deputy Associate Attorney General at the Department of Justice. Two members of the Justice Department's Computer Crimes Unit report. Mr. DeGregory is joined at the table today by Christopher Painter, the Deputy Chief of the Computer Crime Intellectual Property Section at the Department of Justice. Mr. Painter will not be making a separate statement, but will be at the table with Mr. DeGregory to answer questions. I want to thank each of you for being with us here today and for patiently listening to our opening statements. I would ask that you do your best to summarize your testimony in 5 minutes or less, although I don't think anyone will insist on strict adherence to the 5-minute rule. And without objection, your full written statements will be made a part of the permanent record of today's hearing. Dr. Kerr.
Grateful for the opportunity to discuss with you our program for interception, lawful interception of information on the Internet and data networks. As you know, the use of computers and the Internet has grown rapidly and has been paralleled by the exploitation of computers, networks, and databases to commit crimes and to harm the safety, security, and privacy of others. Criminals use computers to send child pornography to each other using anonymous encrypted communications. Hackers break into financial service company systems and steal customers' home addresses and credit card numbers. Criminals use the Internet's inexpensive and easy communications to commit large-scale fraud on victims all over the world. And terrorist bombers plan their strikes using the Internet. Investigating and deterring such wrongdoing requires tools and techniques designed to work with new and evolving computer and network technologies. The systems employed must strike a reasonable balance between competing interests: the privacy interests of telecommunications users, the business interests of service providers, and the duty of government investigators to protect public safety. I would like to discuss how the FBI is meeting this challenge in the area of electronic mail interception. In the interest of your time, I've submitted a longer statement, and what I'll do is try to summarize the high points, particularly addressing some of the questions the subcommittees raised in opening remarks. First, moving to how we protect the privacy interests of telecommunications users requires me to talk a little about the Carnivore system. What is it? How does it work? Put very simply, it's very much like what some in the networking industry would call a packet sniffer. That is, something able to pick out those packets using the addressing information of the Internet, and only those packets to which we've been given access. It works by being placed at a service provider's location in order to get a part of the traffic that's passing through that service provider's portal. In every case, we require a court order. That court order is specific to the numbers we can target, if you will, the addresses we can target, and as to whether it's the equivalent of a pen register, trap and trace, or, in fact, full content recovery akin to a Title III intercept. To be very clear on the point, we don't do broad searches or surveillance with this system. That's not authorized by a court order, and in my view, could not be. The way it works in detail is that once the court order is issued, the system basically has a filter mask, and that filter mask is prepared with an understanding of the court order so that, for example, the Internet protocol addresses that are the legitimate target of the investigation are called out in the court order and set forth in this filter mask. Second, we're able to also sort on the to and from line of the email. And maybe the best way to think about that is think about the piece of standard mail. What it's basically allowing us to do is record the address to which the envelope is being sent and the return address on the outside of the envelope. We're not permitted to read the subject line and, in fact, do not capture that and record it because we're not authorized to open the envelope with either a pen register or a trap and trace order. If we have an order that allows us to recover content, we're able to open the envelope, and in this case what we would then do is capture all of the packets that relate to that email in order to record them on a stable medium, magnetic tape or some other stable medium, for later reassembly at another location. It's installed by a supervisory special agent who has training and experience in fact, responding to court orders of this sort, assisted by one of our electronic technicians, and in every case by one or more technical people from the Internet service provider. And I think it's important for you to note that that team of people that records it or puts the system in place is not made up of the case agent leading the investigation. This is a technical team of 3 or more people. It probably also includes an electronics technician from whichever of our field offices is responsible. We don't look at the text on site until it's recorded and returned either to a field office or to us at headquarters. And the installation, to put a picture in your mind, looks very much like a desktop personal computer. It's often bolted into a rack like other equipment at the Internet service provider location, but an important difference is that it has no keyboard, no mouse, and in fact it's locked up as far as the enclosure is concerned where the magnetic media are written, because this in fact is the first step in the evidentiary chain. And so it's important that it be locked, access only provided to an agent who comes on site to collect the lawfully obtained information, and treats it just like we treat physical evidence in terms of chain of custody from there on. An important further point is that we produce a record for audit of the filter setting and the configuration on each installation. In the first few times that it was used, that was done by the people doing the installation. We've now grown concerned because of discussions that have been ongoing that we record that in a way so that it's authenticated. And so we now, in fact, overwrite it with a hash so that if someone tried to rewrite that audit trail, that could be detected. And that record of filter settings and configuration, in fact, becomes part of the evidentiary record available to the court and the defense as required. There are also sanctions for misuse, and no one should forget that. They're both criminal and civil sanctions that cover both Title III and Electronic Communications Privacy Act installations. It's a federal felony calling for a prison term of up to 5 years, a fine, plus possible recovery of civil damages. And so I don't think our technical teams installing these devices are going to risk their jobs, their integrity, and their future by attempting to operate this equipment improperly at the ISP. Moving on to the method by which we respect the business interests of the service providers. Every installation has in fact been done in collaboration with the service provider's technical staff. To do it efficiently, we in fact only want to intercept the very smallest slice of the relevant traffic. And in fact, where the ISP itself is technically capable of performing the intercept, that is, they have the equipment and the personnel, as many of the large ones do, so they can respond to the court order, we are in fact very happy for them to do that and simply provide us the information which is the subject of the court order, and we never do install our equipment. We also, in those cases, bear some part of the cost of doing that. ISPs come in all sizes. I think there are various numbers of them estimated in the United States at the present time, but it's upward of 10,000. They're not all large listed companies. Some of them are more mom and pop operations. They don't have large amounts of equipment and a great deal of technical sophistication. And where the ISP cannot perform in a timely way under the court order, we're then willing to bear the technical and cost burden by installing our system. Our system is passive on the network. It only receives information through the filter as authorized by the court order, and it emanates no signals and no communications over the network. So we don't believe that it in any way would interfere with the proper functioning of the service provider's equipment delivering email to customers. And lastly, the equipment is removed immediately upon the expiration of the court order. It does not remain at the internet service provider, nor is there anyone who can get in and make a decision on their own to leave it in place. Lastly, does it support us in carrying out investigations in our most important cases? We think it's a well-focused capability. It uses some of the very attributes of the internet, in particular the internet protocol addressing capability, the to and from lines of the email, in order to restrict our collection to just those who are the targets of the court order. In a sense, it's automatic minimization up front. Not to say there's not minimization after the fact, because when the messages are reassembled back at the field office or at headquarters, if we have in fact incorrectly or inadvertently captured information we shouldn't, it's in fact deleted at that time. And it's really no different than the minimization that occurs first real time on a Title III wiretap and then subsequent on the recording of that wiretap to be sure there's nothing there that shouldn't be. It produces evidence with an appropriate first step in the chain of custody. We're trying to maximize the opportunity to properly gather evidence, authenticate it, and be able to testify that we've neither added to nor subtracted nor altered that which we've captured. It's a flexible tool because it's a combination of software and hardware, and so we can, in fact, adjust it to fit subsequent court orders, and we can move from one case to another with it. We maximize the use of commercial software to reduce risk and cost, and as I mentioned before, we've used authentication. Finally, one of the things we're going to do as a consequence of our discussion over the last 18 months with people in industry, staff and members of Congress, 5 of the Department of Justice components, a number of U.S. attorneys, some 15 federal and state law enforcement agencies, we think it's important to lay to rest this question, does this thing in fact do that which we say it does, and only those things which we say it does? And so we are working right now to undertake an independent verification and validation of the software that we use. We're going to do it with academic members of the team as well as industry members. And by the way, we're not going to contract for those people. They'll be selected by the organization that carries this out for us. But what we're going to do is very akin to what, for example, NASA does with software developed for their launch operations. Ask some independent party to verify that the software we have and deploy will in fact do those things that we say it will and not provide capabilities that we should not have. Our year-to-date use of this tool, that is this present year, the first 3 quarters of the fiscal year, we've deployed it some 16 times. It's been used in 6 criminal cases and 10 national security cases. Some number of those were simply pen registers, some involved full content. None of those cases have been adjudicated, so we can't speak to details today, but I think it's probably of interest that it's not a very large number. It is reported in the annual wiretap report in that category called Other. So if you're wondering where the number will be found, either now and in the future, that's where it will be. In summary, I think we've tried to develop a tool not in advance of policy and precedent, but in fact with a great deal of care in understanding the legal authorities under which we are authorized to use this and to target it precisely and well at those that the court orders. Thank you very much, Mr. Chairman.
Thank you very much. Mr. Parkins.
Thank you, Mr. Chairman. I do not have a prepared statement. I'll be very brief. I want to echo, first of all, what Dr. Kerr said. And this is, despite its unfortunate name, this is a tool that is very surgical. And I think Representative Hutchinson had it right that this really is a minimization tool. And I'll leave the technical aspects to Dr. Kerr. What I'm here primarily to emphasize, and I'm delighted to be here and answer any questions that the committee may have, is to emphasize that the FBI and the Department of Justice have a true commitment to the rule of law. And I want to respond just briefly to the notion that we have deployed this system without controls or without proper authorization. That is simply not the case. We are also not saying simply trust us, we're the government. I think we're not naive. We've had enough situations in the course of our history to know that that's not enough. We have significant oversight both within the Bureau, within the Department of Justice, and most importantly within the judicial branch that oversees the deployment of this device and any other surveillance device. In addition to that, we obviously have vigorous and appropriate congressional oversight. So that's why I'm here. I'm happy to answer questions, and I just want to emphasize to you and to the American people that this is a tool that is deployed rarely, and it is never deployed without a court order, and we do not deploy it in a way that exceeds the court order. It is very discriminating, and I hope that this gives us the opportunity to explore that and give some comfort to the committee as well as to the American people. Thank you very much, Mr. Chairman.
Thank you, Mr. Parkinson. Mr. DeGregory.
Thank you, Mr. Chairman. Mr. Chairman and members of the subcommittee, thank you again for allowing me this opportunity to testify about the law enforcement tool Carnivore and the Fourth Amendment. We have seen, as Dr. Kerr has noted, magnificent growth of the Internet over the last 10 years, and it has created vast benefits for our citizens, our businesses, and for governments. And it seems to hold boundless promise if we can harness it. The Internet has spurred a new and thriving economy. Many businesses have prospered by providing their products and services through the Internet. Others have assisted in building, maintaining, and improving the Internet itself. The Internet has given people jobs, supported families and communities, and created new opportunities for commerce for America and for the world. The Internet has touched both our working lives and our family lives. As we have seen throughout history, however, there are those who would use powerful tools of progress to inflict harm upon others. The Internet has not escaped, unfortunately, this historical truth. Even in the Internet's relatively short existence, we have seen a wide range of criminal use of this technology. It has been used to commit traditional crimes against an ever-widening number of victims. ever-widening number of victims. There are also those criminals intent on attacking and disrupting computers, computer networks, and the internet itself. In short, although the internet provides unparalleled opportunities for Americans to freely express ideas, it also provides a very effective means for ill-motivated persons to breach the privacy and security of others. Many of the crimes that we confront every day in the physical world are beginning to appear in the online world. Crimes like threats, extortion, fraud, identity theft, and child pornography are migrating to the internet. The Fourth Amendment and laws addressing privacy and public safety serve as a framework for law enforcement to respond to this new forum for criminal activity. If law enforcement fails properly to respect individual privacy in its investigative techniques, the public's confidence in government will be eroded, evidence will be suppressed, and criminals will elude successful prosecution. If law enforcement is too timid in responding to cybercrime, however, we will, in effect, render cyberspace a safe haven for criminals and terrorists to communicate and carry out crime without fear of authorized government surveillance. If we fail to make the internet safe, people's confidence in using the internet and e-commerce will decline, endangering the very benefits brought about by the information age. Proper balance, Mr. Chairman, is the key. Now, despite the fervor over carnivore, the truth of the matter is that carnivore is in reality a tool that helps us achieve this balance. To satisfy our obligations to the public to enforce the laws and preserve public safety, we use the same sorts of investigative techniques and methods online as we do in the physical world, with the same careful attention to the strict constitutional and legal limits that are imposed upon us. Carnivore is simply an investigative tool that helps us to investigate online in the same way as in the physical world and enables us to obtain only the information we are authorized to obtain through a court order. To illustrate, law enforcement often needs to find out from whom a drug dealer, for instance, is buying his illegal products or to whom the drug dealer is selling his goods. It is therefore important to determine with whom the drug dealer is communicating. In the olden days of perhaps 10 years ago, the drug dealer would have communicated with his supplier and customers exclusively through the use of telephones and pagers. Law enforcement would obtain an order from a court authorizing the installation of a trap and trace and a pen register device on the drug dealer's phone or pager. Now, that same drug dealer, or a kidnapper, or a child pornographer may be just as likely to send an email as to call his confederates in today's world. When law enforcement uses a trap and trace or a pen register in the online context, however, we have found that at times the internet service provider has been unable or even unwilling to supply this information. It is for that narrow set of circumstances that the FBI designed Carnivore. Law enforcement cannot abdicate its responsibility to protect public safety simply because technology has changed. Rather, the public rightfully expects that law enforcement will continue to be effective as criminal activity migrates to the internet. We cannot do this without tools like Carnivore. Carnivore is, in essence, a special filtering tool that can gather the information authorized by the court by a court order, and only that information. It permits law enforcement, for example, to gather pursuant to an order only the email addresses of those persons with whom the drug dealer is communicating, without allowing any human being, either from law enforcement or the service provider, to view private information outside the scope of the court order. In other words, as I understand it, Carnivore is a minimization tool that permits law enforcement to comply with court orders, to protect privacy, and to enforce the law to protect the public interest. In addition, as Dr. Kerr has noted, Carnivore creates an audit trail that demonstrates exactly what it is capturing. And as with many other investigative tools, there are many mechanisms we have in place to prevent possible misuse of Carnivore. The Fourth Amendment and the courts, of course, restrict what law enforcement can do online, with or without Carnivore, as do the statutory requirements of Title III and the Electronic Communications Privacy Act. In the case of federal Title III applications, the Department of Justice imposes its own guidelines on top of the privacy protections provided by the Constitution, statutes, and the courts. For example, before Carnivore may be used to intercept wire or electronic communications, with the limited exception of digital display pagers, the requesting investigative agency must obtain approval for the Title III application from the Department of Justice. Specifically, in the Department of Justice, the Office of Enforcement Operations in the Criminal Division reviews each proposed Title III wiretap application for content to ensure that that interception of content satisfies the Fourth Amendment requirements and is in compliance with applicable statutes and regulations. If the proposal clears the Office of Enforcement Operations, approval must generally be given by a Deputy Assistant Attorney General in the Criminal Division. Typically, investigative agencies such as the FBI have similar but separate internal requirements. If the investigative agency and the Department of Justice approve a Title III request, it still must, of course, be approved by the proper court using familiar but exacting standards. By statute and internal regulation, the interception may last no longer than 30 days without an extension by the court, and courts also often impose their own additional requirements. In addition, remedies for violating Title III or the Electronic Communications Privacy Act by improperly intercepting electronic communications include criminal and civil sanctions. For violations of the Fourth Amendment, of course, the remedy of suppression is also available. Despite this panoply of protections, we recognize that concerns remain about this tool. And as Dr. Kerr has noted, the Attorney General has asked for an independent review of the Carnivore source code to ensure that its capabilities are what we understand them to be. A report generated from the review will be publicly disseminated to interested groups within industry, academia, and elsewhere, and should alleviate any concerns regarding unjustified intrusions on privacy from the use of this tool. Mr. Chairman, my testimony today necessarily highlights a few of the more significant aspects of the balance between privacy and security that the Department believes must be struck. The Department of Justice has provided the committee with my full written statement, and it is my sincere hope and expectation that through this and other fora, those of us who are concerned about privacy and public safety will recognize that responsible law enforcement can enhance both goals. Mr. Painter and I are available to try to answer any of your questions along with the rest of the panel. Thank you, Mr. Chairman.
Thank you very much. Let me say to each of you who have testified that I think your remarks have helped clear up at least some of the questions that have been raised about the system called Carnivore, and I think your testimony has been very helpful to us. I'm going to have a few questions, and other members will have questions. I do want at the outset to acknowledge that we probably not get to all the questions that we want to ask. So we would ask you to provide us written responses to any additional questions that any members of the committee may have. We'd also give you an opportunity to provide any additional comments that you wish to make in light of subsequent testimony that comes in the hearing today. But let me, having said that, let me go over some ground that I think you've already covered concerning the use of Carnivore under the Pen Register or Trap and Trace Authority. When you're using the Pen Register or Trap and Trace Authority, would you ever obtain any letters or information other than those that make up an email address such as johnsmith@home.com? In other words, have you ever or would you ever make a request under the Pen Register or Trap and Trace Authority that included the capture of words or sentences other than the email address?
The answer from our side in terms of how we set it up is that if it's a pen register order, we only get the to address and we capture nothing else.
And I might say also that even the subject line we consider to be content, and that would require full Title III. It's just the addressing information, and that's solely, just as in the telephone context, the numbers dialed, numbers received.
Okay, so it's your understanding that your legal authority is limited to the email address, and of course, it is your practice and has been your practice only to obtain the email address when you're using the trap and trace or the pen register authority.
In the electronic communications context, yes, that's right.
Let me ask you this. In your view, does federal law enforcement have the authority under the Pen Register Act to capture so-called URL addresses, which are the addresses of the websites a person has visited?
If the URL addresses are not really what's contemplated under the Pen Register Trap and Trace statute. What we're talking about there is, I mean, it's possible it could be captured if it, for instance, was a Hotmail service. A Hotmail service, as Dr. Kerr can talk about more specifically in a technical way, is a web-based email service, and so you would capture that part of it that identifies as a Hotmail service and then specifically limits it to a specific authenticating code. I think Dr. Kerr can talk a little bit about that.
If you would.
Yeah, I think that's a very good point. There are services such as Hotmail where we have to capture the web page and then look for the authenticators and other indications that it's an email service. Having done that, we limit the collection to simply the email that's provided through that service. We don't capture the user's other use of the internet. We are not interested in what they do when they surf the web, and we restrict what we do only to that email traffic over the web page.
Okay. Now, in your comments, Dr. Kerr, you indicated that Carnivore has been used only a few times. I think it's 16 was the number for this year. Is that correct?
That's correct. 16 times this year. I think about a total of 25 in the life of the program over the last 2 years.
Well, over that same time period, how many Title III intercepts on email would you have done not using Carnivore?
We've used Carnivore and earlier versions of the same technology, and in some other cases we've used a commercial product to try to capture emails. And one reason that we moved from the commercial product to Carnivore was, in fact, to get some of the selectivity and audit properties that I briefed you on earlier, because the commercial product had been developed for quite another purpose. Products like this are used by the service providers to monitor the quality of their service. In that case, they have no legal restrictions on what they can observe. In our case, we're quite limited and need the more discriminating technique.
My time has expired, but by unanimous consent, I'll have 3 additional minutes. Let me follow up on that. If let me change, give a limited amount of time to a different subject. How many have you contemplated allowing the use of Carnivore by other, not only federal law enforcement agencies, but state or local law enforcement agencies?
At this point in time, we have used it on at least one occasion in support of another federal law enforcement agency. We have not yet brought it to the point where we would be talking about it in terms of providing it to state agencies. As you're aware, the authorities under which they operate are different than at the federal level, and so we're not necessarily assured at this point in time that it would be a suitable tool for us to turn over. That said, anytime we turn over Title III or other intercept equipment to state and local authorities, we do so with the signature of the Attorney General. She has, in fact, the decision on that. We don't.
In my opening statement, I made reference to a media report that Earthlink was required to attach Carnivore to its network in one instance, and doing so caused part of its network to crash and its customers to lose service. Now, from your comments, Dr. Kerr, I understand that just shouldn't happen. So I'd like to hear your comments about those reports and what actually took place there, and whether this system can pose a threat to the functioning of an ISP, and whether you've had other complaints similar to that made by Earthlink.
In the specific case, what I will do is try to give you something for the record that's more complete than I can do right now. But initially, when we went to Earthlink, and they were ultimately compelled to move ahead to do this, they attempted to do it themselves with software that they essentially tried to put together in real time. It didn't work, and it didn't provide information consistent with the court order. It's not clear to us that anything we subsequently did had any adverse effect on their network. And in fact, in at least one other case, we've had quite good cooperation from them. It's the only case where we've in fact had to go back and get the judge to emphasize that he meant the order. In all other cases, we've had excellent cooperation, particularly at the technical level, and normally at the level of the general counsel of the company involved.
I would add also that in any of these cases, you have to work with the service provider to actually install this. The FBI couldn't go in and just do it themselves. So even when the court orders it, and that happens in each case, you have to work with the technical people to install it.
Thank you very much. Mr. Watts, recognized 5 minutes.
Thank you, Mr. Chairman. Let me start at a pretty basic level, Dr. Kerr, and pick up on something that you said in response to one of Mr. Kennedy's questions having to do with your sharing of this tool with other law enforcement agencies. And as I recall, your response was that the authorities of the states are different than the authority under which you are operating. Unless I'm missing something, everybody's operating under the Fourth Amendment to the United States Constitution. So unless you're saying that the Wiretapping Protection Act gives the federal government some additional authority than the states are able to exercise under the Fourth Amendment to the Constitution, or maybe I shouldn't speculate about what you're saying. Tell me what it is you're saying when you say that you're operating under a different authority than the states.
I certainly take your point that the states are operating under the same constitution that we are. But we, in addition, of course, have the Title 18 statute that guide the federal use of electronic intercept.
But that's in, I would take it that that is in furtherance of whatever authority you have as a basic proposition under the Constitution of the United States. It doesn't give you any additional authority, does it?
No, it certainly doesn't. But the point is that some states, in fact, do not have a statutory basis for state and local law enforcement to do electronic surveillance, or they have statutory limitations, all still within the Constitution, but in fact more restricted or non-existent in some cases.
All right. Let me ask another pretty basic question. How long has Carnivore or some predecessor form of Carnivore been in use by your department?
Roughly 2 years. The program began in terms of a development program about 3 years ago, but in terms of actual court orders and deployment over the last 2 years.
Square for me, if you would, the notion that you have now engaged in 25 uses of this, 16 of them this year, or are engaging in them, I guess, on an ongoing basis, because none of them have come to trial yet. And the statement that you made that you are now undertaking or preparing to undertake verification that the system does what you say it does, and that only. It seems to me that such verification would have taken place at some earlier stage, not 25 cases into public concern or legal concern.
The essence of a development program, of course, is that you do learn as you develop and deploy. We, as I pointed out, had initially tried to use a commercial product and found that it did not have all of the properties we thought should be in place for long-term use in a law enforcement context. And so
what properties did it not have that you were looking for?
It didn't have the same discrimination capabilities. It didn't have the same ability to provide an audit report and report on configuration that we require.
Now, who is it that, now that you have the audit capability, who is it that has the oversight at your department to audit to really review the information that you obtain from the audit?
I think that'll actually happen quite outside of the FBI, in that the results of the intercept will in fact be provided to the court. They will of necessity become available to the defense, and consequently they will be more aggressively questioned, in fact, in that circumstance than they would be in any internal administrative review.
The gentleman's time has expired. The gentleman will have 3 additional minutes.
Let me turn to a different area, if I can. You've compared this to the internet capabilities that's analogous to a phone tap, or the authority that you have to tap phones. Does your authority to tap phones get you into the internal phone mechanisms of the phone company, or is your authority limited to tapping individual phones of individual suspects?
That's an area that's in fact in a state of change today.
Who's changing it?
You did, sir. In the
you being Congress, I take it. I think I voted against this bill, as I recall, and still have some concerns about it, to be honest with you. But go ahead. I'm locked with everybody else for that purpose.
Sorry. Some of my colleagues know this better than I, but the point is the communication...
Maybe I should be directing this to Mr. Parkinson. He's the general counsel. He should know these things, I guess. Or Mr. DeGregory. I didn't mean to beat up on the technician here. I just...
In its most basic sense, as I understand it, the telephone tap is conducted at the phone company, but is restricted to the individual line which you wish to tap, whether you wish to obtain numbers dialed, numbers coming in, or whether you wish to obtain content.
Okay, now how does that compare with the capability that Carnivore has for internet communications?
Now I'll go back to the science side.
Not to try to confuse you by switching back and forth, but the telephone...
I'm pretty confused without you switching back and forth, but go ahead.
The telephone tap refers to the ability to intercept switch circuits, which was the basis historically of the telephone system. The internet provides a different kind of technology that we're trying to intercept. It's a so-called packet-switched network. And it doesn't work by my, in effect, leasing a circuit in order to make a phone call from my house to yours, and that's, if you will, for the time of the conversation, our private circuit.
Now, let me stop you right there, because my light's going to go off. It has already gone on. If you needed additional legal authority to get mobile on phone taps, why would not additional legal authority be necessary for you to be doing what you're doing under this system? And maybe, again,
I'll give you my view, and then...
The gentleman have an additional minute.
We do, in fact, have legal authority to do what we're doing today. And I think it's because of the correct belief, from my perspective, that the addressing information on the internet is, in fact, a useful and appropriate analog to the telephone number in the switch circuit world. But perhaps Mr. DeGregory or Larry Parkinson would like to add to that.
I think that's correct, and it's appropriate also to point out that there are gradations of authority, and there's a higher level of authority within the department and a higher level of authority in the courts, depending on what sort of intrusion you're talking about. If you're talking about simply numbers, then we have the pen register trap and trace authority. If you need to go beyond that, then we have to move it up a notch, or several notches, to a Title III authority.
Thank you, Mr. Chairman.
Chairman Hyde.
Thank you, Mr. Chairman. You can understand the skittishness of some people whose concern is privacy, and when you see some of the things that have happened here in Washington, it gives one reason to wonder and to worry. I speak of the Defense Department releasing an employment application with information that was supposed to be private, and it ends up in the New Yorker magazine, and that person, I think he got a letter mildly critical of what he did, which doesn't go in his file, and no prosecution. A less compelling case, I guess, is over the so-called Filegate, where the law wasn't breached at all, but one's sense of privacy took a beating, I should think. And so there are people who are skeptical about how this culture of privacy, how porous it is. That doesn't call for an answer. That's just kind of a comment. Can you tell us how, I'll ask this maybe of Mr. DeGregory, how terrorist cells and organized crime and others use technology, and how does Carnivore address the growing use of technology by criminals?
Well, I think that that terrorist cells and organized crime can use the internet to communicate, can use email to communicate, and simply the same way that a pen register addressed their use of the telephone to perpetrate their criminal activity, Carnivore addresses or can address their use of the internet with respect to those activities and obtain, pursuant to a pen register order, those numbers that are being called by the organized crime figure or the drug trafficker.
Could you tell me what reasons you have for not letting the internet service providers gather the requested information? I take it they have made themselves available to do that for the most part. Maybe some of them haven't. But what are the reasons why you don't let them do it?
I don't think it's a question, and anybody up here is invited to correct me if I'm wrong, I don't think it's a question of not letting them do it. I think Carnivore's use is limited to those situations where the internet service provider is unable to provide the minimized court-ordered information that the FBI requires pursuant to the order.
And let me amplify on that a little bit. The FBI, my understanding is, will always allow the internet service provider to do it if they can, in fact, do it in a timely fashion. The one time this was actually challenged, without talking about who the ISP was, in that one instance, the ISP tried to work with their own tool. It was not effective. It was not capturing all of the addresses. It was only capturing incoming and not outgoing addresses. It wasn't giving the whole information. And in that case, the FBI was forced to use the Carnivore tool. That is not their first line. The first line is to let the internet service provider do it if they can. And in fact, the FBI, I believe, would like the internet service providers to do it if they can.
Fine. Thank you very much. I have no more questions. I'm through, Mr. Chairman.
The gentleman from Michigan is recognized.
Thank you very much. I think one of the basic questions here is to determine whether or not you're minimizing your activities or whether you're maximizing them. And of course, it's already been asserted that you're minimizing them. And my job is to find out, maybe before the hearing ends, but certainly after the hearing, whether that is correct. And it seems to me that this system that we're oversighting today, unlike other trap and trace devices or the others that we use, is subject to the maximization of information, getting more information than is required or is authorized by a court order. And so that's the area that to me is very, very unclear as of now. I'm not sure how we're going to sort this out, but I think we have witnesses here that are going to come forward later on that are going to complain about the fact that there was other information that was available through this system that might not have been available if we weren't going through the internet. Isn't that possible? That you can get more information, you can look at other things that would not have otherwise been available?
One of the points, Mr. Conyers, that I was taking some time with was to try to make it clear that the only information we can capture is, in fact, that specified in the court order. And to go outside of the court order, in fact, is a federal felony with substantial sanctions for those who would do so. We, in fact, think of this as a tool that's designed explicitly to meet the requirement of the court order. We don't have the authority, and nor are our people allowed the opportunity to step outside of those bounds.
Well, right, that's the law. But, I mean, that's the problem. I mean, if I could be assured that everybody wouldn't do the wrong thing because there was a statute making it criminal, that would reduce a lot of our efforts. And even law enforcement people, I hasten to add. Mr. DeGregory.
Mr. Conyers, as I understand the way that the system operates, and certainly that's correct, that's what the law is, but there are checks and balances with respect to Carnivore which would make it extremely difficult for someone to counter those checks and balances and violate the court order. It's not just a situation where, as I understand it, a rogue FBI agent, for example, could broaden the coverage of the Carnivore intercept and violate the court order. In order to do that, he would need to engage the aid of technical people, perhaps even technical people at the internet service provider, and he would also have to find some way to cover up or change the audit trail that is left by the system so that it doesn't expose his going beyond the court order. And again, I'll stand corrected by those who are more expert in the way the system functions, but that's how I understand it. And although, yes, that's the law, there are checks and balances which would make it extremely difficult for someone to violate the court order.
And it's also a law we take very seriously. If a law enforcement person violates the wiretap law, they'll be prosecuted. The computer crime section has a responsibility for doing that and would prosecute particularly law enforcement individuals who violate the wiretap law.
And we've done that. Not in the context of these kinds of intercepts, but in the context of telephone interceptions.
So our assurances are that, first of all, there's a law against it which you would assiduously prosecute your own people were they to violate it, and that there are other technological measures that make it very difficult to do anyway. There's a box that actually can search to preclude getting more information than you want. Is that the way I understand that it operates, Dr. Kerr?
Actually, the way it works is that it's set up in conformance with the order to collect and record that which is part of the order. And instead doing that setup and arranging the configuration, the knowledge of that setup and configuration is in fact recorded right along with the evidence. Once that evidence is collected, it's in fact delivered to the federal court where it's sealed by the judge who issued the order, so, and with an appropriate chain of custody to get it there.
The gentleman's time has expired. Without objection, the gentleman will have 3 additional minutes.
Thank you. I'm not sure if I need them, Mr. Chairman, but let me just say that I don't know, maybe the committee is put in a more difficult position than I appreciate. I don't know if we have any way of verifying the technological part of the response to my question that you've given me. And I know that, you know, unfortunately in the past we've had many agencies, including law enforcement, that have gone beyond the scope of their responsibility. There's hardly anything new about that. So I'm trying to figure out how we're going to get to the bottom of this. We may need technology experts to match yours to verify that what you're telling us makes everybody believe that it's okay, it's the government. And that's what I'm not sure.
Gentleman Yield?
Of course.
I think the gentleman raises a valid point, but I think that has already been addressed to a certain extent by the department's announced plan to have this system reviewed by an independent body of experts who would issue a report that everyone could examine, and I suppose ultimately representatives of the independent body of experts could come here to the Congress and answer questions that we might have of them based on their independent review.
Would the gentleman yield for a question?
Well, yes.
Thank you. I'm just concerned about that. Let's assume that an independent body of experts reviewed the system, said it was fine, and we were doing what it was supposed to do, et cetera. That could change at any time after that. And how would you maintain the trustworthiness that the system was still limited after they had investigated, unless you're going to have an independent group looking over the FBI's shoulder forever? Because obviously you can't trust the police agency forever not to go beyond what they're supposed to do.
Well, I raised this, Chairman Kennedy, merely to point out that we're sort of in the process of taking words for it, and of course we're happy to take the government's words, but, you know, this, as I recall it, Carnivore wasn't sent to us. We sort of found out about it in the scope of things, and it began to take on a life of its own that led to this hearing. So I'm anxious to hear from the non-government witnesses to see how their understanding of what has been happening with this system comports with what we're being told. But I thank the witnesses anyway. That's what your job is about. I mean, that's what you're supposed to do. Thank you, Mr. Chairman.
Thank you, Mr. Conyers. The gentleman from Arkansas, Mr. Hutchins, is now recognized for 5 minutes.
Thank you, Mr. Chairman. On that particular point, y'all are willing to submit the source codes to an independent review and audit. I think the dispute is that the ISP community would like to have open access to the source codes for purposes of reviewing it and determining its authenticity and that it accomplishes what you desire. What problems would you see, if any, in allowing open access to the source code that make up Carnivore? Dr. Kerr?
There are 2 points that we would raise. We wouldn't have any problem releasing it to a group set up to do verification and validation. We would have a problem with full open disclosure because that, in fact, would allow anyone who chose to develop techniques to spoof what we do an easy opportunity to figure out how to do that. Beyond that, some of the code we have used is, in fact, commercial off-the-shelf software, and it's proprietary to the companies that have developed it, and we're not at liberty to divulge their source code under the license that we've paid for.
So you would be open, though, and it would not compromise legitimate law enforcement activities if there was a ongoing review system of the source codes for Carnivore or any subsequent adjustments to it?
I think the only concern we'd have at some point is, you know, when is enough enough? Do you review it each time you set it up for a new case? I don't think that's workable. Do you do it as part of an annual review of electronic surveillance beyond simply counting the occasions when it's in use? That may be more workable. But clearly, when the number of reviewers are larger than our group that develops the system, we probably have reached some form of imbalance at that point.
Thank you. Now, let me, if you have a content court order to use the Carnivore system, then of course you have to show probable cause, you got to get your court order. But at that point, is innocent third-party information reviewed by Carnivore?
If we have, in fact, gotten proper information on the target addresses and the to from, because that's important too, since more than one person might be using a particular computer, in principle, we should only get the authorized communication. That said, if we were to find that we had, in error or because of misinformation, recorded something to which we were authorized no access, we would have to minimize that just as we would on a normal telephone wiretap.
It's been explained to me as a pipe in which Carnivore looks at all the data going through the type to seize that which is the subject of the court order.
Right. In fact, one of the...
Is that pretty much...
yeah, one of the problems is that the pipes are too big for us to do that, and we rely on the service providers to give us just part of the traffic coming through their big pipe.
Okay. And I've learned on computers that sometimes delete does not mean delete, that information continues to be stored. And so my question is the information that is not captured pursuant to the court order, is it ever retrievable in any form by any means?
No, it's not, because it's all in random access memory and volatile memory. So, for example, if the power goes off, we will lose everything in that memory. None of it gets to the...
What if the power didn't go off?
Well, none of it gets to a stable recording medium like magnetic media in a hard drive or a zip drive, a floppy disk. Only that which we're authorized and which the filter is set up for gets to that permanent media.
Now, you indicated that year-to-date, Carnivore has been used 16 times, I believe 20 times in all total. How many of these, of course, these are the ones that use a Carnivore, is that correct? But did you also, in addition to that, use court-ordered wiretaps or pin registers to retrieve Internet information by using ISP capabilities?
In some of the cases, we've, in fact, been able to ask the ISP, and they have provided us the information.
I'm trying to get a contrast. The 16 that you mentioned, were these not by using ISP capabilities? This is when the FBI went in and used the Carnivore system. Is that correct?
That's correct.
All right, so I'm trying to get an idea how many others are out there that were used by ISP capabilities.
I don't have the number with me. We could certainly provide it.
Does anyone know that? I mean, I'm trying to figure out if we're looking at 100 others versus 16, or...
My understanding for the Title III intercepts is it's not a large number. Trap and trace, it might be a little larger.
We can try to obtain those as much as Dr. Kerr provided.
The gentleman's time has expired. The gentleman have 3 additional minutes.
Thank you. I mean, it just strikes me that, I mean, considering the number of Title III wiretaps of telephone communications, I mean, that's much greater than the 16 or what you've used by ISP. And I guess what I'm leading to is that it looks like if the bad guys are moving as the whole population is moving to data communications through the Internet, looks like we're missing a whole lot here. That we're really only on the surface of what we might need to be doing.
That's certainly true. The tool we've been discussing to this point today, Carnivore, has in fact only been used in the framework of email intercept. As you're properly pointing out, there's a lot of other traffic on the network. We continue to work to try to see how we could develop appropriate and lawful tools to go after that traffic as well. It would tend, again, to try to use the properties of the network itself, the need for me to be able to move data from my computer to your computer and capture it because of the addressing information that would be there, not by trying to view the content on the fly.
Would the gentleman yield?
Yes, have a yield.
I don't understand what other kind of traffic you're talking about if it's not email. Like what realm are we talking about if we're not talking about email?
Well, one could use other protocols, for example, to move large files, to move imagery, to move larger quantities of data. And it wouldn't move as email in the sense that we've been talking about it today with a, from me to you, subject, whatever. It might just move as a block of data. It could, in fact, be information that companies are moving from one location to another.
Have you ever had occasion to try to retrieve any of that information pursuant to court order?
We have not had any occasion that I'm aware of where we've tried to intercept that kind of information. In general, large files like that, we would expect to come to rest someplace, and we would probably be picking it up as another part of an investigation.
Finally, there's, looking ahead a little bit, there was a question as to whether the PIN register orders that are applied to the Internet reveal far more than the numbers that are dialed in traditional telephone wiretaps. And I know that you're restricting it to from information. You've specifically deleted capturing the subject information because that would be content-oriented. But this is still a concern, I guess, that even the two with the address, sometimes a descriptive term, do you see, have you in fact, from your history of the 16 instances that Carnivore's been used this year, have there been instances in which you captured more information that you believed you needed pursuant to a PIN register type capture? That you believe might go into the content area, and therefore you had to minimize it?
The gentleman,
just finish this, and I'll be done.
yeah, the gentleman's time has expired. The gentleman have one additional minute.
I'll reserve the opportunity to answer carefully after review, but there are none to my knowledge.
So in other words, you're saying the system's working, you're not capturing content information beyond that which is intended under the court order?
That's correct.
Thank you, gentlemen. I yield back.
Thank you, Mr. Hutchinson. The gentleman from New York, Mr. Nadler, is recognized for 5 minutes.
Thank you, Mr. Chairman. Forgive me if I ask any question that may be repetitive, since because of a plain delay I arrived late to the hearing. As I understand it, the Carnivore can be used either for content or for, in effect, a trap and trace, just to know who a person is communicating with. Is that true?
Yes, that's correct.
So it can be used for either purpose?
Yes.
Or both? And whether it's used for either purpose depends on the nature of the court order?
That's also correct.
And it can be set either way?
It's in fact set specifically to meet the terms of the court order.
Now, when you have in effect a trap and trace, you want to know who someone is talking to. This is for past tense or for ongoing?
Basically, we would capture under the trap and trace pen register order the to and from information. It would be recorded.
No. Is it past tense? You get a court order, you want to know who this guy talked to in the last 2 months, or you want to know who's talking to in the next 2 months?
It's perspective.
It's perspective. Now, what is the difference in terms of what you have to show? Presumably you have to show probable cause that a crime may be committed. Why would you sometimes ask to know only who he's talking to and sometimes what's being said, if they're both perspective?
I'll let my colleague lead with that one, please.
It depends upon the nature of the information that you have available to you at the time. You may not have enough information at the time that you seek the pen register or the trap and trace order to establish the probable cause necessary to seek the order, the Title III order for the content.
But you have enough you need a lesser standard of probable cause to get a trap and trace?
It's not a probable cause standard at all. It's simply a certification to the court by the prosecutor or the law enforcement agency that the information that will be obtained through the use of the pen register and the trap and trace or the trap and trace is relevant to an ongoing criminal investigation.
With no probable cause?
With no probable cause.
So you can get on anybody with no probable cause?
That's correct. And I want to point out to you that that the Supreme Court held in Maryland versus Smith, I believe, in 1979, that there was no reasonable expectation of privacy in numbers dialed by a telephone, because essentially when someone turns over information to a third party like a telephone company, they should not have either a subjective or an objective reasonable expectation of privacy in that information.
And does that mean that when I send a letter, there's no reasonable expectation of privacy as to whom I'm sending the letter? In the snail mail? Could you get north to the post office to tell you without any probable cause who is sending me mail or whom I'm sending mail to?
We do mail covers all the time, which essentially do that.
Without probable cause?
That's right.
That's very interesting. Let me ask you a different question.
May I just have one more thing, Mr. Nadler? The authority under which we operate is codified at 18 United States Code, I believe it's 3125 with respect to, or 3123. 3121 at sec, which includes 2325.
Okay. Now let me ask you a different question. You started using this Carnivore system about 2 years ago? And no one ever bothered telling Congress about it. We just found out about it because Earthlink complained about it?
Well, no one ever bothered telling Congress in the sense of all of Congress. There certainly have been members and staff briefed on it over the last year. It's been widely...
Judiciary Committee staff?
Excuse me?
Judiciary Committee staff?
Yes.
Mm-hmm.
It's been rather widely discussed with industry, internet service providers, other companies that provide software and hardware to the network. It's been fairly substantially briefed within the Department of Justice, including at the training center in Columbia, South Carolina, where the U.S. attorneys and AUSAs go for training. All of the major investigative programs have been briefed.
What institutional safeguards have you set up to make sure that the assurances that you've given us, that information given by gathered by Carnivore on subjects not under investigation, is not used?
Every time that it has been used, it's gone through the internal review of the FBI that all such uses require. My colleague Larry Parkinson can speak to more detail on that. Second, it goes to the Office of Enforcement Operations in the Department of Justice, where it's in fact reviewed prior to ever going to a court to get a court order. So there's a very substantial level of review internal to the FBI, internal to the department, as well as the subsequent review of the court before an order is issued.
Subsequent review of the court? I'm sorry. I think I asked, once you have Carnivore online, what institutional safeguards do we have that information gathered by Carnivore, presumably after the court issues an order to install it, is not misused?
The gentleman's time has expired. The gentleman will have 3 additional minutes.
Thank you.
The answer to that is that particularly in a full content intercept, that the information we intercept and record is provided under seal back to the court, which can itself determine that we've properly followed the order.
It's provided back under seal to the court?
Correct.
Is there a proceeding in the court?
I don't know.
If there's not a proceeding in the court, it'll simply be placed in storage. No one will look at it.
No, that's not completely true, because it's placed under seal with the court in the Title III content intercept. And then at some time in the future, the court can, under Title III, make that available to, for instance, the person whose conversations were intercepted or his defense counsel.
Now, if a person has been the subject of such an order and his content has been intercepted, or simply that whoever he was emailing to has been made known to the FBI, and it's determined that this person should not be subjected to any charges, did nothing wrong, is he ever made aware that his privacy was so violated?
Under Title III, under the provisions of Title III, if a Title III order is denied by the judge or if it expires, after a certain period of time, I believe it's 90 days, there has to be notice to the people whose conversations were intercepted. I think that's been done very broadly, as I understand it.
So people whose conversations were intercepted or on whose email there was a trace are eventually told.
Under the provisions of Title III, when you're dealing with content, yes, that's correct.
And what about when you're not dealing with content, when you're dealing with a trap and trace?
Well, again, a trap and trace, and I should emphasize something that Mr. Gregory said earlier. A trap and trace, the reason probable cause is not required is this is a very preliminary investigative step. It is really literally the addressing information and nothing more.
I understand that, but if without probable cause to believe that I've committed a crime or done anything wrong, if simply as part of an investigation you have followed who I'm talking to by email, or for that matter not by email, you put a trap and trace on my phone for the last 6 months, and now you've determined that there's nothing further to investigate, do you ever tell me that my privacy was violated in that way? Do I ever know about it?
I don't believe that there is any requirement for disclosure in the law, and I understand you're using the term that my privacy was violated, and only relying upon the case law, which indicates that there's no reasonable expectation of privacy in such information. I would just want to make that point yet again.
Well, that may be from the Supreme Court's point of view that there's no reasonable expectations of privacy, but I think as a practical matter, most people would be somewhat upset if they thought that someone was following exactly who they were talking to on the telephone or who they were mailing emails to. But be that as it may, from a legal standard, that may not be. The fact is, there wasn't, in a practical sense, there was an invasion of privacy. Government gathered information that maybe I didn't want people to know. I think I should know about that. And maybe I should be able to say to the government, on what basis did you do this? Do you have any reason to do it? And maybe they did, maybe they didn't. But right now, there's no provision for that.
Well, first of all, the prosecutor has to certify to the court that it's relevant to an investigation. And then second, it's that class of information alone, and it's limited to a period. It can't be done ad infinitum. A trap and trace order is 60 days.
Can it be renewed?
It can be renewed, but it has to go back to
renewed?
court. I'm not sure there's a limitation.
What's the longest anyone has ever been subject to this?
We'd have to look into that to be sure.
Has anyone ever been subject for more than, let's say, a year?
Again, I don't have that information available at this point.
5 years? Could you rule it out?
I mean, I don't. If you want us to try to find out the longest time that anybody has ever been subjected, we can try to do that. I don't know if we have those records, but we can try to do that.
Thank you, Mr. Chairman.
Thank you. The gentleman from Alabama is recognized for 5 minutes.
Thank you. The potential for abuse here is tremendous. Would y'all agree?
Congressman, I guess I don't agree with that.
Right. And you don't have to give an explanation.
But I think at a certain point in time, we have to rely on the good faith of public servants who have a number of checks and balances.
Well, I think you're exactly right. I think what you're saying is trust us. You have to rely on us. And what that reminds me of is these IRS agents who use the information to check up on their ex-spouses and their boyfriends and their girlfriends and potential adversaries for affections. And all this we've heard for really years and years and years. J. Edgar Hoover, what he did. But let's talk about those checks and balances, because I think you're exactly right. I think you certainly have to rely on that, because you can't go to AT&T today and say, we're going to analyze all the phone calls that come through your system, can you?
That's correct. We can't do that.
But you can do that with Carnivore, with...
No, we in fact specifically don't do that. We only...
No, I mean, but you do have to analyze, or do you have the ability to analyze everything coming through that information stream, don't you?
No, we in fact restrict what
you restrict it. But you have the ability to monitor...
We don't have a system with the capability to do the real-time processing of that much information.
But you can move it around and just capture whatever you want on that system. Or you don't have the ability to go to...
We don't have the right nor the ability to just go fishing.
Well, you have the ability to monitor anything within that information stream.
No, we in fact have the lawful opportunity to collect some very specific information.
No, okay. You might not have you say you don't have the legal ability, but you have the technology to monitor that information stream, anything in it.
We are not sitting looking at the information stream and moving our filter around. It's in fact put in place with a court order. It's not...
But you have the technology to go in and monitor every one of those emails on the system, if you want. Not all of them at once, but you could monitor here, you can monitor
certainly there. If you had access to the system, yeah. In principle, you could do that.
But you do that, and you can't with telephone calls.
Well, in fact, depending on where you are in the telephone system and what kind of switch you're in, you might be able to do a great deal. But again, it's the same thing. Remember, the big telephone switches are simply computers as well. And so if you got into one, you presumably could see a lot of traffic. Okay. The fact is that there are a lot of bars to our doing that, starting with the law.
They're safeguards. They're safeguards.
It's the law. It's illegal to do that.
Okay, I mean, it's the law. That's one of the checks and balances. Safeguards. Now, one of those was, you said the Justice Department. You have to go to the Justice Department and notify them and get their approval. And you said that it takes a higher level of authorities there to get approval for your activities. Is that correct?
What Mr. Parkinson was saying is that for the trap and trace and pen register, which only allows addressing information, it's a different level of review. But to get content where probable cause needs to be demonstrated,
you have to go higher up.
It in fact takes high-level approval in the Justice Department before we are ever able to go to the court.
Let me ask you this. Why did Janet Reno not know about this, although it's going on for 3 years, and she is, in fact, the Attorney General?
Well, I would remind you that the Department of Justice is some 127,000 people in multiple investigations.
I think that's a valid point. There are 127,000 people over there, and we might have to...
I believe that Attorney General Reno said that she'd known about the capacity to do this. She was interested in taking a closer look at the system's application and implementation to ensure that we're balancing privacy and law enforcement needs, and I think that's what's going to happen with respect to
so she didn't know about
verification and validation.
All right. How about Echelon? I understand that the National Security Council testified before Congress and said that they routinely shared information they gathered with Echelon to law enforcement agencies. Do they share information with the FBI?
What you're referring to, of course, is whether the National Security Agency,
through their Echelon program, do they?
Through their various intercept programs, may from time to time appropriately share information with law enforcement. But there are in fact some very important hurdles there, including the Classified Information Protection Act and others, so that in fact the primary purpose of a system may have been intelligence collection. Incidental to that primary purpose, it may have collected important information about a crime either committed or being planned, and there are mechanisms to take advantage of that.
The gentleman's time has expired. Without objection, you'll have 3 additional minutes.
Yeah, Echelon, as I understand it, they monitor all telephone calls, all emails, all faxes. Is that your understanding?
I think we should defer to the National Security Agency to talk precisely about echelon. I don't think we're prepared to talk about it today.
I guess I would just ask the FBI, do they do share information? You say when he said they routinely shared information with law enforcement agencies, do they share information with the FBI?
We have, as you probably know, a very significant national security responsibility in addition to law enforcement. So it is not uncommon at all for the National Security Agency to selectively share pieces of information that it may acquire. But it does so, as Dr. Kerr pointed out, with significant hurdles and legal constraints.
I think you've raised a good point. I'd like to use that as my final question. And that's, you say the National Security Council, I think we all presume they're dealing with national security. But then they gain information on another subject. I mean, if it's national security, obviously they could share it with you. But let's say it's another subject. Or let's just say that we're talking about carnivore. What's the name of it? Carnivore. Okay. Now, the examples you gave us were about espionage or terrorism. But do you use this, say, in antitrust investigation? Would you use it in income tax evasion cases? Can it be used in, say, OSHA investigations or EPA violations? Or are there any restrictions there?
It would, of course, have to be a federal felony to come under Electronic Communications Privacy Act, and it would have to be, in fact, one of the predicate offenses under Title III to come under those authorities. So, no, it's not every offense. Clearly, Internet fraud would be an appropriate target. Child pornography on the Internet would be an appropriate target. These are major programs within the FBI that we would...
Can you, other than email, can you get into files? Do you have the ability to get into someone's files?
We have in at least one case been able to intercept using a different protocol, file transfer protocol, but with relatively small files. We can only get at what we have the addresses for within the protocol that's being employed.
But once you have that in the passwords, you could actually get into maybe a mainframe or someone's database?
No, we're only authorized what the court order says. It's not a matter of going and doing exploration or surveillance with the tool.
Well, gentlemen, yield for a second. Does that extend to emails that have already been transmitted? If you had the address, would you have the authority and/or the capacity to go in and either look at the content of a prior email or look at the number or instances in which there has been communication to deliver that email?
The gentleman's time has expired. The gentleman will have one additional minute.
Thank you. And let me, after he answers it, may I have my minute then?
Shall I try to answer Mr. Watt's question? Okay. The carnivore system basically deals with message traffic on the fly. If the messages have already been sent and received, another way we, for example, might get it would be if, for example, a search warrant were offered and we seized a computer and we found the messages on the hard drive of that computer. Or as one of the members of the subcommittee pointed out, deletion doesn't necessarily mean deletion. We can, in fact, sometimes recover messages even though they have been thought to have been deleted. And we have a unit that does that, but they work under a more normal search warrant environment.
And under certain circumstances, stored communications that are held, stored email communications held by ISPs can be obtained by search warrant as well.
All right, here's my final minute. You mentioned
The gentleman will have one additional minute.
You mentioned judicial oversight. And Dr. Kerr, you mentioned that you've got the defense attorney, and he's looking over our shoulders. You have the judge, he's looking over our shoulders. And obviously, if the defense attorney has the ability to do that, that is a pretty potent weapon in limiting what you do. But are you saying, when you say that all these cases are ongoing criminal cases in court where there is, in fact, a defense attorney? Or could it be, what about a case of an investigation where there's no attorney or no active court case?
Well, I think Gregory pointed out the provisions of Title III that would lead to judicial notice of those who had been intercepted. They certainly, at that 60 or 90-day point, having been informed that their communications had been intercepted, would take a great interest with or without their attorney. So I think the system is oriented very well to protect their privacy and rights.
Are you unable to take information you gain from these investigations and pass them on to other law enforcement agencies about unrelated investigations, or is that information off limits?
The gentleman's, I'm sorry, the gentleman's time has expired. The gentleman's had more time than anyone else. We have a limited amount of time. The members of the panel can answer a written question about other things the gentleman might want to ask, but Mr. Barr is entitled to have his time. So, Mr. Barr is recognized.
Thank you, Mr. Chairman. This is actually quite fascinating. The Clinton administration is fascinating. It never ceases to amaze me. For almost a year now, at the other end of this very hallway, in the Government Reform Committee, we've been having a series of hearings, the conclusion of which, from the Clinton administration standpoint, is we don't even know how to keep track of our own emails. And now we have a very sophisticated system for tracking other people's emails. The fact of the matter is, I think they know exactly what has happened to their emails, and they know exactly what's happened. I just think that we have two different directions for the Clinton administration. When they want to protect themselves, they have one standard. When they want to get information on other people, they have quite a different standard. And the fact of the matter is, with all due respect, simply because there is a Privacy Act or simply because there are sanctions in Title 18 for misuse of the Title III provisions does not guarantee that nobody in this or any other administration will abuse it. So I think we really need a little bit more than simply saying that there are provisions in the code. The problem that I have with Carnivore, several problems, but the fact of the matter is Carnivore is not a passive system. It doesn't sit there like a basket and these emails just sort of drop into it. It is very much an active system, and it has to have some mechanism for scanning the information in that ISP stream in order to pull out what the court order allows you to pull out. The problem, let me ask about two things, though, that are particularly problematic. As you all have testified earlier with regard to Chapter 206 of Title 18, which are all of the provisions we've been talking about that govern trap and trace and pen register, you're doing something very different here, and that bothers me. With traditional trap and trace and pen registers with phone numbers, as you all have testified, you get an order. Granted, the threshold is substantially lower than a Title III, and we understand that. You get that from a court. A court has to grant it. There's no discretion for the court. And the telephone company, as it were, has to comply with it. They can't just give you the high hat and say we're not going to do it. They have to comply with it. And you tell them what you want, and they give you what you want. And if they don't, then you can bring sanctions against them because they are required under the statute to do that. You're doing something very, very different here. What you're doing here is you're going to that ISP provider, which stands in the shoes of the traditional phone company when you're looking at a traditional hard number trap and trace or pen register, and you're saying, we're not satisfied with what the statute says, that you have to install this and give us the information. We don't trust you. I don't know why what your rationale is, but you're saying, what we're going to do is we're going to go outside of the law here, basically, and we're going to force you to allow us to put our software into your system. You will not be able to monitor it. It's completely unsupervised, and we're then going to take it from there. Thank you very much, guys. You just give us access and we'll do our thing. That's very different from the way trap and trace and pen registers work under the traditional Chapter 206 scheme. Also,
also there's new legal ground that you all are trying to break here and establish the precedent that I don't think is existing anywhere in federal law or case law, and I know you're trying to make it in the Earthlink case, where you're saying you have the authority to go in and sort of harvest large quantities of information and you'll filter out what you want. I think those are two very, very large steps that we're taking here. I don't think this has been well thought out, and that's two areas that I have concern about. Why is it not sufficient? Because we have both testimony as well as a number of articles that indicate that Internet service providers have indicated, and I haven't seen anybody refute it, that they can do the very same thing that Carnivore does, but do it in a way that is much more protective of the privacy of the Internet service provider users. And certainly, if you would go to Earthlink, for example, and say, this is the information we want, the same as you would do it with a phone company for a trap and trace or pen register, they would be obligated to give that information to you. And if somehow you had evidence that they were not doing it, or that they were not capable of doing it, and I don't think that's the case, then you could seek sanctions against them. Why is it in both of these areas you're trying to break new legal ground? What is it that's insufficient that you don't like about the existing statute that you're willing to operate within the bounds of it?
Let me answer with respect to that last point, whether or not there's been cases where the Internet service provider could not provide the information. And Dr. Kerr can talk about this as well. There have, in fact, been cases. And one case, without mentioning who the provider is, in fact, the Internet service provider was not able to provide all of the information. In that case, in fact, it wasn't just a matter of them saying, well, we have to comply with the court order. They went back to the court. There was a proceeding before the court. All of these issues, including the issues about too much material being grabbed by this program, or that was at least the argument that was raised, were raised with the court. And the court ordered this device to be put in place.
And that was not the Earthlink case?
Again, since that was an ongoing criminal case, I don't want to mention who the
let's not play niceties here. I'm asking, was that the Earthlink case? Because that's been reported in the newspaper. It's not like some great dark secret. And I think you are describing the Earthlink case.
I think the problem is this is an under seal proceeding. There's a court order in that proceeding. I don't want, and because it's an under seal proceeding, we could talk about the public facts that were argued at the hearing, but I don't want to mention the name of the provider.
I thought you said at the beginning it wasn't the Earthlink case.
I did not say that. I said
okay.
I don't want to.
I think it is.
But in fact, in that case, there was not complete information given because only the incoming messages were trapped, but not the outgoing messages. And there was some evidence to that effect that was presented to the court in the form of affidavits.
But that's very different from the testimony that we've had from Earthlink.
And what I was going to say is, it's certainly the policy, as I understand it, the FBI, and the preference that if in fact the Internet service provider can provide that information and do it in a timely fashion, that's what they prefer. It raises this sort of example.
The gentleman's time has expired. Without objection, the gentleman will have 3 additional minutes.
Thank you. Are you saying then that in every one of the 25 cases in which Carnivore has been used, the only reason that it has been used is the Internet service provider has told you they cannot provide the information that you need?
That's my understanding. I defer to Dr. Kerr to also address that.
I think that's generally the point. In fact, our favorite outcome is that if the Internet service provider can, in fact, provide the information to us covered by the court order, that's what we would like to do. And there's some very large Internet providers not too far from here who have the entire capability to do that. At the same time, in some of the over 10,000 ISPs around the country, you'll find some that have very limited technical capability. Their capital structure is very small. They're not in a position to buy equipment and set up a capability for us that may only be used once in the entire business history of that company. In those cases where they can't perform, we're prepared to take the technical and cost risk away by bringing in our Carnivore system and employing it.
Here we go again. I guess what you're telling us is Carnivore is sort of the privacy advocate's best friend. That hey, I mean, you have ISPs breaking down your door and saying, please install Carnivore. I don't think so. Is there any specific statute or case law, other than perhaps the Earthlink case, which is currently pending, as I understand it, that provides authority for the government to go to a provider of electronic information, a telecommunications firm, and say, give us everything you have and we'll filter out what we have? That's very different from the traditional rationale underlying both Title III and Chapter 206, which is the government can't go in and just harvest everything on its own and then filter it out. You tell somebody exactly what you want, and that's all that you get.
In the case to which, in the case referred to by Mr. Painter, we successfully relied upon the pen register statute, and I know of, and I stand corrected if someone has a correction to make, and I know of no other case where an ISP has challenged our reliance on that statute.
No, but what I'm saying is there any statute or case law other than this one case that, as I understand it, is still in litigation?
And I'm saying we've relied on the pen register statute successfully in this area, and there are no other challenges other than the one mentioned by Mr. Painter.
The Department of Justice position is that Chapter 206 provides statutory, therefore also constitutional authority, I guess you would argue, that that the government has the authority, the right to go in and harvest a large category of information far beyond simply the target, and then itself take out the targeted information.
The gentleman's time has expired. The gentleman will have 1 additional minute.
I think when you use the term harvest, you're using a term that really doesn't apply here. That's not what it's doing. It is only harvesting. It's only capturing the information specifically that you allow, and the court order has mandated.
But in order, I mean, this is what I love about the Clinton administration. Then you get into this circular argument, so much metaphysical. You have to have some way of going in there and finding what you're looking for. Otherwise, it's a non sequitur.
Let me, as a part of the non-political agency here, try to answer your question directly. What do we actually do in the Carnivore system? What we do is we first ask the ISP to bring us the smallest part of the message traffic that would contain the target messages. We then bring it to an interface where, in fact, a clone of that reduced set is made. The regular message traffic goes on unimpeded to the legitimate recipients of it. We then filter the cloned stream of information, and the packets that do not pass our filter, because we're not allowed to record them, in fact vanish at that point. The only thing that passes our filter are the packets with the appropriate addressing information to meet the court order. And I think we've demonstrated that to a number of times. In fact, we appreciated your visit some months ago when you saw it. As to how,
when I saw what?
When you were at Quantico, some of the demonstrations we gave you were, in fact, of these capabilities.
Well, that was years ago. That was on Kalia. That was like 4 or 5 years ago. That had nothing to do with Carnivore.
Well, no,
I hope it didn't, because it wasn't described to me as Carnivore.
Hadn't been named yet, perhaps. But the point is that we're not scanning the full message traffic passing through an ISP. In fact, to do it effectively, we want to use the smallest subset of that. A very sophisticated, larger ISP will, in fact, give us the ultimate subset, which is the target messages, and we would have to install nothing. In some cases, we have to provide technical assistance by putting our system in the ISP in order to do that final filtering.
The gentleman's additional time has expired. I want to thank all the members of this panel for your testimony. I think we've had good presentations in your testimony, and the questioning period has been, I think, very helpful. We will have additional questions, as I indicated at the outset, and we will do our best to send those to you very soon, and I would ask that you do your best to respond to us within a very short period of time after you receive the the letter which we will send with the questions. Again, we thank you for your testimony and your assistance to the committee in this oversight responsibility. And now we'll move to our second panel.